We've been away, busier than ever on cases and moving offices, and now we're back. And a lot has happened since our last podcast, including this. Victor McKoy versus D.C. Department of Employment Services. Another win for Morris E. Fischer, LLC. This one is really special. This is the equivalent of a technical knockout in boxing. This is a win by TKO. This was a summary judgment win by our law firm. Imagine that. Most of the cases that are won, almost all of them, by plaintiffs, the employee who brings the case require a hearing. It is the defendant who tells the judge, there's no reason to try this case because of whatever's in the record. Dismiss this case on what's called summary judgment. And there's something like 90% of these summary judgments are granted in federal court in Maryland. DC has somewhat of a lower statistic. This is unusual because this was one where our firm said in a motion, Judge, there's no reason to try this case. The employee, Victor McKoy, should win. And this judge, Michelle R. Harris, Senior Administrative Judge in the District of Columbia before the Office of Employee Appeals, agreed with us. And bam, just like that, without a trial, Victor McKoy wins. So a very, very good win for our office and for Mr. McKoy. Here are the details and the highlights of this case. So the plaintiff here, the employee, he's fired. He is a tax examiner for DC Department of Employment Services, otherwise known as DOES. And the story with Mr. McKoy is that he's got some conditions, some medical conditions, and if those conditions combine with the coronavirus, very, very serious injury, possibly death. I mean, you're talking real problems here for this man. And what he wants to do is he wants to work from home. And he's a tax examiner. And one of the first questions in the case is, can this man do this job from home? And the answer is absolutely. So here's what he does. He asks for reasonable accommodation from June to August of 2021. Now, this is where this case gets a little weird because his reasonable accommodation is let me work from home. And Doe says, well, we need to see medical documentation, certificates, the whole shebang. And he provides that to them. And there comes a point where he keeps working, but they never actually tell him, certainly not in writing, yes, your thing was approved. Your reasonable accommodation was approved. He doesn't know that. So now he gets an instruction after that period, well, you have to now come back to work. And he files another reasonable accommodation. And they say, well, we've got a million questions about this. What's your medical condition? What's your job? What's the essential functions of your job? Can you do them from home? And the guy's like, well, wait a second. I told you all this. I told you all this months ago, and you went ahead, and I assume you granted my accommodation. I mean, I don't know, because you never told me whether you did or not. And what is deficient about what I told you? I don't even know. How could I possibly ask my doctor to correct something that we don't even know what's wrong with it in the first place? And this is a big, big key in the case. There was an email where there was intra-office communication, and Doe's admitted that it failed to properly process Mr. McKoy's request for reasonable accommodation. They had to tell him about it. They didn't tell him about it for a number of months. That's a problem. Because now when you're getting these notices of what's wrong, why you can't do the job here, and why you have to do this from home, and the judge points this out. This is basically a gaslighting case. This is a situation where the DC government made a gigantic error in the processing of reasonable accommodation. And what they did to try to fix that error was just pretend it didn't happen and turn the error on the employee. That's it. It's your fault, Mr. McKoy, because you didn't submit whatever you were supposed to do. No, he did. He did. He submitted it. You either lost it, you didn't pay attention to it, you admitted the error far too late, because that was one of the documents we got in the litigation. That's why there's a litigation. The judge didn't like that at all and gave this case to Mr. McKoy and awarded his job back and back pay and the whole shebang here. And this is a TKO. There wasn't even a trial on this. It was like the judge is like, okay, Mr. Fischer, it makes sense to me. Anything you have to say, DC government? No, they come in with the same stuff they've been saying all the time. Bam, this guy wins on summary judgment. It's a very important case because it's the quintessential gaslighting employment case. The employer makes a mistake. The employer doesn't admit the mistake. The employer tries to then go after the employee rather than admit the mistake that it made. The employee loses his job. The employee is forced into a lawsuit, basically wrongful termination case. And wow, now what comes out in front of the court in a public setting is you, the employer, in this case, the DC government, you were the ones who screwed up here, not Mr. McKoy. We're not looking at what Mr. McKoy could have done better, okay? And you'll notice in your relationships with your employer or even your significant others, you'll know the difference between good relationships and bad relationships, okay? Bad relationships, they take the slightest thing you do and they make it sound like this is the worst mistake ever. And they totally downplay or don't even admit what they did. And this is a case where the judge really sticks it to the DC Department of Employment Services. If you are going through or have had a wrongful termination, please contact this office. It is what we do, and we can help you. And we also invite you to subscribe to our YouTube channel. And also, we invite you to send any comments you may have if you want to hear future podcasts on some issue that's really important to you that we haven't done yet. Let us know that, and we can do that.